With a view to start, let me explain what I would like to do in the next half an hour. I will try to understand what is the impact of the rule of law on the future negotiations in the field of asylum between the United Kingdom, so this fresh third country, because of the Brexit, the withdrawal, and the European Union. And I will depart from some reflection that have been made last week in the closing section by Stefano Montaldo on the inapplicability of mutual trust per se to the judicial cooperation within the area of freedom, security, and justice, and why I will make this a bridge between criminal law, so cooperation in criminal matters, and cooperation on asylum. Because, of course, those two fields of competence of the European Union share a common development at the jurisprudential level by the Court of Justice concerning the relevance of the rule of law, not only as a general parameter for external action in light of Article 2 and Article 21 of the Treaty on the European Union, but also as an instrument to ensure the sustainability and effectiveness of intra-EU cooperation within the judicial field, so within the area of freedom, security, and justice. And with a view to doing so, I will try to address two fundamental questions. The first one is about the form and substance of future EU-UK relations on asylum, taking them from the rule of law lens, so taking into account the rule of law impact on these relations. And the second question is about the impact of a hard Brexit option on asylum, on fundamental rights and rule of law within the global European legal space. And I will end up with some conclusion on the paradoxical results of Brexit from this perspective. But let's dive in. And in order to start, let's move on from the state of affairs concerning EU-UK cooperation on asylum. And it has been already described very well by Monica, saying that the completion of Brexit meant the end of Dublin Third regulation for the UK. So no more first irregular entry rule applying between the two parties, and no more transfer for family reunification purposes from EU member states to UK. So we see that the end of Brexit meant a lot of dysfunctionalities for both parties. On the one hand, the UK is now forced to retain responsibility for asylum seekers, being the first irregular entry rule criterion of Dublin inapplicable towards the European Union. But on the other hand, the problem is also on the EU side, because of course there are a lot of people, of asylum seekers, trapped in the European Union countries without the possibility to reach their families in the UK. And in the midst of this dysfunctionality, one of the package which has seen some development is cooperation on unaccompanied asylum seekers seeking children. Even though this attempt did not result in any conclusive agreement, we can use some of the developments in this field as a case study in order to address our rule of law question. So, which are the possible cooperation models on the ground? The UK government has proposed a bunch of it. We can first of all highlight the proposal by the UK government of two comprehensive agreements between the European Union and the United Kingdom, one on readmission, so a general scheme on readmission of third-country nationals in irregular status, and the second on the transfer of unaccompanied asylum-seeking children, so a very marginal part of unaccompanied minors, only asylum-seeking unaccompanied minors. The second option, which has been displayed by the UK as a second best in case of impossibility to speed up the process on a EU-wide agreement, so on a point A, is the conclusion of bilateral agreements between the United Kingdom, and individual EU member states on post-transition migration issues, a definition which is not immediately clear or intuitive. And the third option, which has been envisaged by the UK, is a non-cooperative strategy. And this strategy has been detailed in the new plan for immigration proposed by the UK government in March 2021. Let's start from option A. So let's start to see what are the rule of law constraints to the feasibility of option A, so a EU-wide agreement, from the formal viewpoint. And so let's start from the one of the criticism which has been highlighted in the negotiation, which is the lack of mandate, the alleged lack of mandate. And in particular, we have to acknowledge that one of the criticism, the reasons pointed out by the UK government in order to justify the inconclusiveness of negotiation is the unwillingness by EU negotiators to consider UK proposals for a global agreement on unaccompanied children seeking asylum. The problem with this affirmation is that it is completely unsubstantiated if we have a look at the legal text, which are relevant in order to shape the relations, the negotiation relations between the two parties. The political declaration setting out the framework for future relations makes no reference to unaccompanied minors, nor the draft text for an agreement on the new partnership with the United Kingdom, nor the withdrawal agreement, even though we can find some reference to cooperation in relation to external action, so towards Africa and other financial instruments for a refugee in Turkey. But we cannot find any reference in this text to cooperation in the field of unaccompanied children seeking asylum. The second point raised by the UK government has been the alleged fluidity of EU negotiators' mandate. And in order to understand why this second point cannot be acceptable from a rule of law perspective, a strict rule of law perspective, so taking into account the material constitution of the European Union, is that Article 218 on the Treaty on Functioning, as interpreted by the ECJ, is a constitutional norm. So it's an article, it's a norm of constitutional character, enshrining the principle of institutional balance from its external perspective, so that it is quite rigid and must be abide So even though no imposition of detailed negotiating positions is possible by the Council on the Commission, it is also true that the Commission cannot distort or extend its mandate beyond the scope of the Council authorization, nor it can derive an extension by analogy of its mandate. And this is quite problematic in the picture that the UK has given of the unwillingness on the part of the European Union to negotiate an EU-wide agreement on unaccompanied minors. Let's now move to the substantive aspect of the feasibility of option A from the perspective of the rule of law. So let's consider rule of law constraints to the content of the UK draft agreement on unaccompanied minors, which is our case study. And in particular, having a look at the contents of this draft agreement, which has been made public in May 2020 by the UK government, we cannot find, to say it better, any reference to hierarchical criteria for allocation of responsibility for asylum claims, so that the decision on the transfer of the minor remains a total discretion of the state in which he or she is present and has lodged an asylum request. But we also observe a total lack of common transfer and take charge procedures. So there is a lack of common shared procedures. And last but not least, the key point to be addressed is the exclusion, the explicit exclusion of direct effect on individual in Article 12 of this draft agreement, according to which nothing in the agreement shall be construed as conferring rights or imposing obligations on persons, nor as permitting this agreement to be directly invoked in the domestic legal system of the parties. And the rationale of this provision is quite clear, because one of the reasons why the United Kingdom decided to break up the marriage with the Union is to avoid direct effect. So this is a clear statement of the Brexit rationale within the framework of asylum cooperation. But why this is not acceptable and make this type of cooperation unfeasible from the perspective of the rule of law, the European rule of law? Because actually we have to consider here the interplay between the rule of law, mutual trust, and fundamental rights within the area of freedom, security, and justice. And this has two main consequences in terms of external action. The first consequence is the need to avoid in external action any detrimental effects for future, for judicial cooperation within the EU. So external action cannot hamper judicial cooperation within the EU, within the area of freedom, security, and justice. And in order to respect this obligation, any agreement with the UK should be provided with a guillotine clause. So a clause allowing the suspension of judicial cooperation should fundamental rights protection fall below the EU standard or the standard negotiated within the agreement. And this is a clear consequence of landmark rulings by the ECJ. I will not go in deep because I know that fellow speakers before me have already dealt with this topic. But just let me say that this is such a strong, an important, a cornerstone rule of the European Union that it applies also in case of asylum for EU nationals, and this has been ruled today in Hungary versus the European Parliament, in which the Court of Justice has said something quite important, that persistent violation of fundamental rights challenging the rule of law in Europe may even rebut the presumption of safety enshrined in Protocol number 24. So what does it mean in terms of external action, in terms of feasibility of cooperation on asylum between the European Union and the UK? It means that we cannot take anything for granted, and the European Union cannot accept any cooperation diminishing this rule, so impacting on the protection of the rule of law and its intertwining relation with fundamental rights, which is, of course, at the very foundation of the presumption of safety, which implies mutual trust, as we know from opinion 213 of the Court of Justice. So, what is our second point to be addressed as far as feasibility of option A is concerned? The second point, deriving from the interplay between the rule of law, mutual trust, and fundamental rights within the area of freedom, security, and justice, is the need to preserve the functioning of the right to an effective remedy. Justiciability of fundamental rights before national judges is a fundamental element of the European Union Material Constitution. And it has been acknowledged in Article 47 of the Charter, which incorporates the conceptual universe within which the defining principle of state government governed by the rule of law operate. This is quite an interesting definition I found in an opinion of the Diouf case. What can we derive in terms of judicial protection for the individual? First of all, that asylum legislation giving concrete expression in the material field to Article 47 of the Charter shall enjoy supremacy on national law. And second of all, that when national law provides no remedies for violation of EU-derived fundamental rights, national judges shall declare jurisdiction to issue remedial measures. And this is quite a high threshold that cannot be hampered by external relations in impacting the right to an effective remedy, as it would be the case should the draft agreement on an accompanied minor be adopted in the reading, in its actual reading, especially of Article 12. Thus, this can be a sort of explanation of the deadlock of negotiations in terms of option A, so in terms of bilateral relations between the EU and UK on asylum matters. We can then ask ourselves whether option B, so bilateral agreements between selected EU member states and the UK are feasible from the perspective we have adopted, so from the perspective of the rule of law. And again, we can apply the twofold approach of formal and substantive aspects. So let's start from the nature of EU external competence. And let's start from acknowledging that within the trade and cooperation agreement, there is a joint political declaration on asylum and returns, according to which it is noted the intention of the United Kingdom in engaging in bilateral discussion with the most concerned member states on asylum matters, but also on family reunion for unaccompanied minors or illegal migration in accordance with the parties' respective laws and regulations. This acknowledgement has brought Chris Philp, which is the Ministry of Immigration in the UK, to recognize that there is a feeling in the continent that when a member state talks to us bilaterally, it is somehow not quite abiding by the rules of the club. Is this just a feeling, or is this more than a feeling, as the title of a famous song? From the perspective of the rule of law, it is of course more than a feeling. And it is more than a feeling, basically, because external cooperation on the redistribution of asylum seeker is an exclusive competence due to conditional exclusivity under Article 3, Paragraph 2 of the Treaty on the Functioning Rule. This, of course, does not exclude the possibility for selected member states to request Council authorization in order to conclude bilateral agreements with the UK. But why should continental state do such a thing? Let's consider political and geographical reasons not to do so, because basically one of the consequences of Brexit is that the UK cannot send back people to Europe anymore, or at least cannot do it in the terms and supported by the presumption it enjoyed within the framework of Dublin. So this option is quite theoretical. We could also envisage the possibility of accession to the Dublin Convention. We know that the Dublin Convention is an international treaty concluded in the 90s, and that this international treaty is, however, tightly connected to the EU framework, in particular with the EU asylum framework. And it is also tightly connected to Schengen cooperation. And that is why third countries enjoying an association regime to Dublin are also Schengen parties. In other words, the functioning of Dublin Convention is tightly connected to Schengen cooperation, as they are a single package in external relations. So when an association regime has to be established with a third country, this would be therefore complicated for the UK, that before Brexit enjoyed special status under Protocol 21, a differentiated status, according to which, according to Protocol 19 and 21, actually. And the one concerning Schengen is Protocol 19, excluding the participation of the UK to Schengen. While under Protocol 21, the UK could opt out from the measures adopted under Title 5 of the Treaty on the Functioning, so the area of freedom, security, and justice. And this possibility, so the default rule under Protocol 21 is the opting out, while the United Kingdom could opt in to selected measures adopted under Title 5 of the Treaty on the Functioning. In other words, this pick and choose approach is in contrast with any participation of the United Kingdom to Dublin Convention, as this participation would be linked to Schengen, something the United Kingdom did not accept before Brexit and will not accept after Brexit. We can then ask whether bilateral treaties already in place with EU member states could factor in a sort of Dublin-like cooperation. The problem in this case is that all the agreements, or the bilateral agreements in place, let's make the example of Le Touquet Treaty with France, do not refer to Dublin-like cooperation and are miles away from referring to that. In other words, they concerned mostly the implementation of border controls and joint patrolling of the borders, which of course is not an exclusive competence of the European Union, nor expressly nor conditionally. But we can also envisage a potential impact of the unfeasibility of bilateral agreements in this field on internal measures, on totally internal measures. And the example here is the so-called DUBS relocation scheme. The DUBS relocation scheme is a unilateral and voluntary scheme adopted in order to transfer unaccompanied minors from Europe to the UK in case of non-application of Article 8 of Dublin Third Regulation before Brexit, of course. This was adopted before Brexit. In other words, we are dealing with unaccompanied minors with no family links, and therefore not included in the personal scope of Article 8 of Dublin Third. What is the problem here is that this unilateral voluntary scheme is based on bilateral agreements with EU member states, namely France, Greece, and Italy, concluded within the framework of Dublin cooperation. And therefore, the end of Dublin may, of course, impact the willingness of those member states to continue having liaison officers in their Dublin unit, UK liaison officers in their Dublin unit. But option B could be challenged also from a substantive perspective. So here the reference is to the contents of the draft agreement on unaccompanied minors in light of the new Pact on Immigration and Asylum 2020. And why? Basically, because according to the new Pact of the European Union on Asylum and Immigration, and namely according to the proposal for a regulation on asylum and migration management, there is a total blurring of EU competencies on asylum and migration. And this blurring makes it very, very difficult to envisage bilateral agreements between EU member states and a third country on very selected and specific issues, such as the one proposed by the UK. But this is not the only reason. Another problem could be the provision of solidarity mechanisms, which do not allow any, which may make it possible to choose among different types of solidarity, but not to avoid, to skip completely solidarity. So again, any pick and choose, any cherry picking approach would be outlawed. And the third point is financial incentives, because this proposal put forward substantive, important financial incentives from the EU budget in order to transfer and to foster family reunification of minors, unaccompanied minors. So the single package claim is reinforced. And we can move, therefore, to the third option, impact of hard Brexit in the field of asylum. What could be the impact? What is the impact of the lack of cooperation on the ground between the EU and its member states on the one end and the UK on the other end? This impact can be assessed at different levels. The first is, of course, the protection of asylum seekers in the UK. And here we have to take into account the new plan for immigration, which has been presented by the UK government in March 2021, accompanied by a statement on legal routes for the protection of unaccompanied children, which however has been defined as a smoke screen. And why? Because one of the main reasons leading the pro-Brexit campaign is the contestation, the open contestation of asylum and immigration policies, as you can see from this picture that I added to the slide. And this new pact is problematic from the perspective of the rule of law and the protection of fundamental rights in the relation with the European Union, because it is based on a controversial understanding of fairness in asylum matters. At the very foundation of the new plan, there is, in fact, a simple principle. And the principle is that no spontaneous asylum flows are allowed. Because spontaneous flows are consequences of an abuse of the right to asylum. And against this abuse, against abusive requests, the UK proposes automatic presumption, a massive use of automatic presumption of safety of third country, including EU member states, and the development of strong rules on strong procedural rules, avoiding escape from the banning. This is, of course, accompanied by the war on smuggling and the smart borders and a number of other measures I will not deal with. But the key point here is what we accept as a definition of fairness. And how can we envisage a cooperation with a third country when the definition of fairness within our legal order, the European Union legal order, and their legal order is so different? What does it mean in practical terms? Could this situation, so the divide between the European path on asylum and the UK path on asylum, open up a new and unconventional asylum route in Northern Europe? Can we expect flows of asylum seekers from the UK coming back to Europe because the conditions of living, the treatment, and impossibility to enjoy their rights is unbearable, and therefore they are forced to move back to Europe? It is not an easy question to answer, actually. What we can say at this stage is that cooperation on asylum is still an area of common interest. And the lack of shared solution is still dysfunctional on both sides. And why it is dysfunctional on both sides? First of all, for the lack of shared commitments, which means lack of mutual confidence in judicial cooperation, which means that EU member states will not be obliged to accept transfers from the UK, but also that the UK will not be obliged to take back secondary movements into the EU. And this, of course, led to uncertainty about the UK asylum standards after Brexit. Now, this situation has been foreseen, we can say, in the case law of the ECJ, and namely in the MA case, where the question from the referring court was about the applicability of the presumption of safety under EU law during the transition period. So the answer we had in MA is not applicable after the transition period. But this means that the ECJ could be called to say something on this point in the near future. And the second problem here is the applicability of the rebuttable presumption under the European Convention on Human Rights. So can we still apply the MSS and Tarakel jurisprudence? We have to remind ourselves that this jurisprudence was tightly connected to equivalent protection rule regarding the European Union. And therefore, we have to acknowledge that also in this field, we might be back to serving, as Lord Kerr told us in the Supreme Court case, Air versus Secretary of State for the Home Department in the case of EM Eritrea. In other words, we cannot apply any presumption of safety without taking into due account the individual situation of the claimant. And this also means that the attempt by the UK to avoid the backlash of hard Brexit in asylum matters by envisaging in the new pact a massive use of presumption of safety for third countries, including European Union countries, would be challenged before the Court of Justice, the European Court of Human Rights. Sorry. I don't know if I think I'm running out of time, right? Okay. So if you want, I can stop here. There could be also an option D, which regards the potential role for UK judges in leveling up UK asylum law to EU standards. But if you want, I can leave it for the debate and just very quickly go to the paradox.
Daniela, sorry, I think that this is quite interesting as a point. So
okay.
Otherwise, I mean, I would ask you in the discussions. I think that the role of judge accompanied us since yesterday. So I think that this is very relevant to us.
Okay, I will be happy to address it. I just don't want to abuse of my time. Can we envisage an option D? So option A is unfeasible for a number of formal and substantive reasons. Option B is complex and raises other challenges from both perspectives. Option C is dysfunctional on both parties. Can we think of option D? So upholding, on the one hand, the international obligation to which the UK is bound in the field of refugee law and non-refoulement. So could UK judges bridge the enlarging divide between protection standards at the EU level and the UK level in the field of asylum by using international law? This is the first point, so we could say D1. And here, of course, the main problem is the lack of judicial remedies in international agreements on refugee law and asylum standards, let's say in general, making rights enforceable before national judges. But national judges, UK judges, could also refer to the concept of retained EU law in the field of asylum in order to try to make an attempt to bridge the divide between UK and EU fundamental rights protection in the field of asylum. What is the definition of retained EU law according to the EU WA 2018 as amended in 2020? First of all, it includes EU-derived domestic law implementing the first round directives of the Common European Asylum System. Because as we have already anticipated, before Brexit, the UK enjoyed a differentiated status, and it could decide whether or not to opt in measures adopted under the area of freedom, security, and justice, and also, of course, the Common European Asylum System, which is a part of the area of freedom, security, and justice, according to Protocol 21. And therefore, the UK decided to opt in to Dublin Third and Eurodac, but avoided to do so for the directives on qualification, on procedures, and reception. As a consequence, the first round directives have been incorporated in UK law and are considered as retained EU law. The second category of acts that might be relevant is EU directives, but not in general, just for the provisions of those directives, which have been recognized to have direct effect according to case law adopted prior to the end of the transition period. So prior to the so-called EIP completion day, implementing period completion day. We have to acknowledge that the retained EU law, however, excludes Dublin Third Regulation at Eurodac, but also, and this is quite relevant for domestic judges, the EU Charter of Fundamental Rights under Section 5. But this is not enough. This is not enough, because we could also have a look to another concept which has been invented with the Brexit, the concept of retained EU case law. Retained EU case law is important because it bounds the interpretation of retained EU law to the jurisprudence of the Court of Justice, with all its consequences in terms of supremacy and so forth. But what is the tricky point of this legislation? It's in the exceptions, in the details. The evil is always in the details. And in fact, if we have a look at the exceptions, we see that, first of all, decisions by the Supreme Court could exclude the application of retained EU law. So the Supreme Court is empowered to exclude any sort of application any sort of use for retained euro. And it can do so by applying the test it has developed in order to change jurisprudence, so to change its own jurisprudence. The second exception, this is even more challenging and has been included in the 2020 reform of the UWA, is the broad and constitutional significant, and I'm quoting, ministerial power to authorize non-application of retained EU case law, but also to designate other judicial bodies other than the Supreme Court having the power to depart from the Court of Justice of the European Union interpretations. In other words, it is open to the government to add other courts to the list of tribunals and judicial authorities which are empowered to make retained EU law not working within the framework of the internal legal order. But the UK government is also empowered to determine the test for non-application of retained EU case law, which of course has an impact on the interpretation of a retained EU law. Of course, on top of this, we have to highlight, to stress that retained EU law may be amended in any moment by the UK legislator. Of course, this is another challenge. And the last point is about the possibility of UK courts to have regard to Luxembourg jurisprudence handed down after the completion of Brexit. This is the only lighthouse in this quite grooming picture I'm giving you of the functionality of this retained EU law and EU case law. In other words, it is left to UK courts the possibility, which of course is not an obligation, to have regard to Luxembourg case law handed down even after the completion of Brexit. So after the IP completion day. But we have no idea of the way in which UK courts will use this possibility. And it's quite interesting, this could be quite interesting to study national jurisprudence in order to say whether UK courts are interested or not in making use of this possibility. And I can now come to my last slide, which is also my provocation. My provocation is option E, or what I have called the Brexit effect on UK cooperation in asylum matters. And this is a sort of vicious circle, if you want. I'm not very able with the PowerPoints, otherwise I would have made it circular. But the circle starts, of course, from the Brexit. So leaving the EU to gain back sovereign powers, so to make the UK great again. But leaving the EU, of course, meant in the field of asylum the end of privileges that the UK enjoyed as a full member. And this is quite problematic when the UK wants to restart a cooperation with the EU under international law, so as a fresh third country. And why? Because international cooperation, as we have tried to say, requires integral respect for the EU acquis, for EU values, but also for the rule of law in its interplay with fundamental rights and mutual trust, making judicial cooperation within the area of freedom, security, and justice effective. So effective within the EU. It is not enough for international cooperation in this field so affected by this interplay between rule of law, fundamental rights, and mutual trust to ensure basic respect of EU values and rule of law in external relations. It is also necessary to avoid any impediment on judicial cooperation within the area of freedom, security, and justice. And this may render options A and B feasible. Moving on to option C, so the hard Brexit scenario, here the conclusion we reach is quite paradoxical, because the conclusion is that only a unilateral acceptance by the UK of the EU asylum acquis and respect for the rule of law in the EU terms would avoid the dysfunctionalities. So the UK left the European Union to gain back sovereign powers. But as a consequence of losing its privileges as a full member, and as a consequence of the interplay between refugee law and rule of law and mutual trust and fundamental rights, the UK sovereignty in asylum matters led to the impossibility to transfer asylum seekers back to the European Union. And so it is an empty box. And I thank you very much for your patience and look forward to the discussion. Thanks.